Hi, I'm Chris Oplensky, an editor at hr.blr.com. February is here, and many of us associate the month of February with Valentine's Day. And many of us associate Valentine's Day with love and romance. But if you're an employer and you take the word workplace and put that before the term romance, the hair on the back of your neck might stand up. And if that happens, then you have probably either experienced a workplace romance gone wrong, or you're concerned about the repercussions of such a relationship going wrong. I'm here today to talk with hr.blr.com legal editor Joan Farrell. She's going to talk to us about workplace romances, why employers should care about them, and what they can do to limit the potential negative ramifications of such relationships. Hi, Joan.
Good morning. Okay.
Why should it matter to employers whether coworkers engage in romantic relationships at work?
It matters to employers because they are exposed to potential legal liability if a relationship goes sour. If coworkers engage in romantic relationships at work and they maintain professional conduct in the workplace and they live happily ever after, there's no problem. But relationships don't always work out that way. Sometimes a relationship falls apart and the resulting tension makes it difficult for the employees to work together effectively or even to maintain professional conduct. Sometimes after a relationship ends, one person will claim the relationship was not consensual and there will be allegations of sexual harassment. Sometimes one employee continues to pursue the relationship after it ends, and that kind of unwelcome behavior leads to sexual harassment claims. And that's just when the relationship is between coworkers. Relationships between a supervisor and subordinate create a whole different set of problems because of the imbalance of power. If things fall apart, there can be claims of sexual harassment or retaliation. For instance, if a former girlfriend gets a poor performance review or less desirable job assignments after a relationship ends. So an employer is justifiably concerned about problems like conflicts of interest, claims of favoritism or unfair treatment by other subordinates, and allegations of sexual harassment or retaliation.
What steps should employers take to protect themselves from potential problems that could arise from a workplace romance?
Employers can have a policy that prohibits romantic relationships in the workplace, but a policy like that is very difficult to enforce. And it turns the employer into the romance police, trying to figure out if employees have violated the policy. And because people spend so much time at work, romances are going to happen. So it's better for employers to have policies to manage the situation when coworkers become romantically involved. One option is to require employees to notify the employer of the relationship. This gives the employer some protection from allegations of sexual harassment. Another option is to require the employees to sign a consensual relationship agreement, it's sometimes called a love contract, confirming that the relationship is voluntary and that the employees will comply with the employer's policies against sexual harassment and retaliation. The privacy laws in some states will limit an employer's ability to have these kinds of agreements, so employers need to check the laws in the states where they're located. For supervisors, an employer can have a policy that prohibits supervisor-subordinate relationships and requires the supervisor to report the relationship. The policy can require reassignment or transfer, so there's no reporting relationship between the employees. But employers need to be careful about transferring the subordinate to avoid claims of retaliation or discrimination. And in the policy, the employer should be clear about its business reason, like avoiding conflict of interest. It's also important to make sure all employees understand the employer's policy against sexual harassment and retaliation, and that they know the procedure for reporting harassment or inappropriate conduct. And training on harassment prevention should include information on social media and the latest communication technology, so that employees understand that comments that are inappropriate in person or by email are also inappropriate when they're texted, tweeted, or posted on sites like Facebook.
Great point. Well, thank you, Joan. Joan's areas of expertise include sexual harassment, hiring, civil rights, and disabilities. To learn more about Joan or to read her byline articles on these and other topics, visit her webpage at hr.blr.com/community/HR editors. For more videos featuring Joan and other hr.blr.com legal editors, visit our HR Video Resource Center. For hr.blr.com, I'm Chris Oplensky. Thanks.